very much, Richard, for your introduction, and to B4 as well for hosting us today. Thank you as well to everyone who's tuned in for logging in on a grey Monday. I hope you're all keeping well. So today you're going to hear from me and my colleague Paula. We're both partners at Julian Taylor Solicitors. We are a specialist employment law practice based in Oxfordshire. So we spend our time advising employees and employers on a whole range of legal issues relating to the world of work. And today we thought we would share some information and tips on recruitment issues. So I'm going to start by handing over to Paula, who is going to start by talking to us about adverts and interviews, and also taking positive action to increase diversity. So I'm now going to do a bit of IT wizardry and share my screen. Hopefully you can see that. Yay. Can you see my? Yes, good. Okay. Right. So yeah, over to you, Paula.
Excellent. Yeah, I'm going to kick off this afternoon now, isn't it? This afternoon, looking at recruitment tips, and one of the key areas of concern for employers when they find that they do have to consider recruiting employees, and that's the discrimination risk. Normally speaking, the main risk that people come across, either because claims are brought or at least they're just worrying about, is indirect discrimination. The fact that they're asking for some sort of qualification which impacts on one group more than another, and they may not even really have considered that. So that's one of the main concerns. It's less likely these days that we come across direct discrimination, which an example of that would be, I'm not going to recruit you because you're a woman, because you're a man, because of your disability. It does occasionally get alleged, but most employers are careful enough now to at least try to not fall into that particular bear trap. However, there's still risk out there because there are such a number of protected characteristics. I've listed these actually in date order pretty much when we got protection under legislation. Now this is all being brought together under the Equality Act, but it started off many moons ago with the basic protections of sex discrimination and race discrimination. Sex discrimination morphed and expanded as it went along to cover issues such as pregnancy and maternity. It also covered discrimination on the grounds of marriage, which now has been extended to cover discrimination on the grounds of civil partnership. And as time and society developed, we've also developed protection for gender reassignment situations. That firstly was brought under sex discrimination, but now is a standalone protection for individuals, so we can't discriminate against them on the grounds of gender reassignment. The next heading that I've put in, disability discrimination, personally, I think this is one of the trickiest situations, in that disability isn't as simple as a person in a wheelchair. The actual definition of disability is really quite wide-ranging, and it's any mental or physical impairment which has a substantial and long-term effect on somebody's normal day-to-day activities. So breaking that down, it's actually an incredibly wide definition. And this is one of the things that we end up having conversation with employers about, in that quite often a person will have a hidden disability, or a disability which a manager may just simply not realise is a disability. Classic examples that we come across in practice in interview and recruitment situation is in relation to disabilities such as dyslexia, which of course can impact on people when they're going through the process, especially if you have, say, a computerized process which involves people filling in multiple choice questionnaires. And these for larger employers are now quite common if you have to differentiate between thousands of applicants for one role, quite often there is a level of technological involvement. And one of the things you do need to consider if you're putting that in place is, will that impact against somebody who has a disability, who doesn't deal with questions, computers, multiple choice as easily as somebody who doesn't have that disability? We will come on to that in a little bit more detail. But other protected areas, age, and of course everybody's got an age, so potentially anybody could be discriminated. Are they too young for the role, too old for the role, are they of childbearing age? So it's not just older people, it can be younger people, or it can be people who think that they are being discriminated against because they see themselves as not of an age which is attractive to that employer. Religion and belief, that can be a protected characteristic, as can sexual orientation as well. All of those now protected characteristics under the Equality Act. So the breadth of that discrimination protection is wide. And there are undoubtedly a lot of employers out there who are just sitting there going, I'm never going to recruit because the dangers are so wide. There is actually quite a lot of guidance and help that you can get in relation to recruitment. We will keep coming back to this series of guidance which ACAS has published online, and we've given you links as we go through, and it's really practical, straightforward, sensible guidance which is available to you. So looking at the next slide, one of the questions we often get asked is, well, disability, does that mean we can't ask people about their health? In fact, it is a good step to ask a question which is in relation to, are there any reasonable adjustments that we can make to help you with this process? Zoom in some ways has helped us massively because it takes out some of the physical adjustments, although in its own way it can give us issues in relation to, can people operate the Zoom? Have they got a disability which impacts on that ability? So yes, it is fine to ask questions about disability if it's asked in the framework of, what can we do to help you? Of course, lots of employers, or some employers, certainly ask questions about physical health to do a job. One of the potential guidances we would give on this is make sure any questions are relevant to the skills required for that particular role. And maybe it's safer to take the or to raise the questions, to take the point closer to the job offer, because then at least you haven't asked irrelevant questions of people which may make them think that they've been turned down for the role because they've disclosed their disability. So moving on to the other protected characteristics, can you ask questions about those? Of course, lots of employers ask questions right at the beginning. Equality monitoring, the equal opportunities as it used to be. It's quite common to have equal opportunities monitoring forms in the recruitment process. Key rule is keep it confidential. Ideally, keep it away from the interviewer and make sure that it's not being seen as influencing any of the decisions. It is useful to have that information if you're doing gender pay reports. It's useful to be able to see where individuals fall out of the process. For example, do you get less women applying for the roles rather than men? Or they're getting to interview, but then women are falling out of the process at that stage. And you can see how these things are happening, how potentially recruitment is impacting on one group more than another. As I've said, the main risk in this whole process is in relation to indirect discrimination. And as we'll go on to see, there are some protections there. But the key point is that ensure your questions are related to the skills needed to do the role. And then going on to ensure that the requirements for the role can be justified. Where we see sometimes employers come adrift on this is the situation where they copy a previous job advert And it may well be that they advertised for the role 5, 6, 7, even 10 years before, and things have changed. And if you have a gap between the skills actually needed to do the role and the skills that you're asking for in the adverts, that's going to cause you problems. So moving on to the next slide, we discuss where you can lawfully discriminate. And where you can discriminate is in the situation where you've got what we call an objective justification. And that is a good business reason for asking for the requirement, which is proportionate, appropriate, and necessary for the role. And we cannot achieve that in any less discriminatory way. And objective justifications can be used in 3 situations. If there's an indirect discrimination claim, so say, to use an old-fashioned example, people required to do this job must not be over 6 foot. Vast majority of individuals over 6 foot are going to be men. So are you indirectly discriminating against men? Yes, unless you've got an objective justification. There is another situation that it can be used in, and that is in relation to a specific protection in disability situations, which is that people cannot be discriminated against for a reason which is connected with their disability. So it's not because of the disability, it's not indirect discrimination, but it's something arising from the disability. We call that a Section 15 claim, and that too you can objectively justify. And the way that age discrimination is slightly different from other legislation is because we can objectively justify age discrimination as well. So we've got to show, as I said, that we have a good business reason for doing what we're doing. There is no less discriminatory way of achieving that. And that can give you an objective justification. There is one little thing that I should mention, that there are very rare cases where protected characteristics are essential for a role because they relate to the main tasks. Be very cautious of this. This has changed over time. I remember when we used to be able to say that, well, you can't have a man cleaning women's toilets. And believe it or not, going back 15, 20 years, that was something that a lot of local authorities would have used as a explanation for discrimination. It's very rare you can rely upon these, but just so you know, they are there for your protection. So just to touch on one next point, positive action. Positive action, this has a really bad press actually. And what positive action is doing is it can only be used in very, very specific situations. And that's where your workforce is not in balance. You have disadvantaged or potentially underrepresented groups within your workplace. So say you have a predominantly male environment, you are allowed to take positive action to try and even that out. It can be either to make the workplace fairer once people have been engaged, or to take action when you're hiring people. This is not saying that you can hire the weaker candidate because of their sex or race or disability. What happens, actually, that's a bad example because disability is one of the few exceptions where you can positively discriminate. But say take sex and race or sexual orientation. If you know you are underrepresenting those particular characteristics, then what you can do when the candidates are equivalent in their abilities, so equally able, you can use the protected characteristic as a tiebreaker where they're underrepresented. As I've said, the one exception to that is disability discrimination, and that is the one situation where by law you are allowed to positively discriminate if disabled people are underrepresented in your workforce. All right, Nicola. Nicola, you're on mute.
Oh, thank you. Thank you very much. It wouldn't be a proper Zoom without a bit of that, would it? Thank you. So yeah, I wanted to talk about screening candidates, and in particular screening in relation to social media. So what we mean by this is looking at profiles on sites like Facebook, Twitter, LinkedIn, even blogs, when looking at candidates to assess their suitability for your vacancies. While there's no specific rule against doing that, there are legal issues with that kind of screening. And the first one, and this links in with what Paula's just been discussing, is the discrimination risk. A key risk is that by checking social media profiles, you could end up discovering information about a candidate that would lead to inferences of discrimination, so that if that candidate is subsequently unsuccessful, they could argue that they've been discriminated against in the recruitment process. So for example, you check out somebody's Facebook, you find out information relating to marital status, pregnancy, ethnicity, sexual orientation, religion or belief, or other information. A candidate could subsequently claim that you are using that information as a basis upon which not to hire them. And the danger is that even if you haven't used that information when making your decision, the very fact that you've looked at a social media profile and have therefore become aware of, or perhaps potentially formed a perception of disability, age, ethnicity, etc., could put you on the back foot in defending a discrimination claim. So from a discrimination perspective, it's certainly better not to check on social media profiles. And for these reasons, the ACAS guidance advises against social media checks. And I have put a link to that guidance there for anyone who wants more detail on that. The ACAS guidance does recognise that certain sites, for example, looking on LinkedIn, would be less controversial than searching on a more personal social media site such as Facebook. Although you should still take care when checking those sorts of more professional based sites to make sure that you're not using any information you discover there in a discriminatory way. And that's basically because people using sites like LinkedIn have more of an expectation that that information will be used in a recruitment process. I think in any case, the important thing is to really look at what is it that we're looking to find out here, and is what we're doing proportionate to achieve that aim. So keep your any searches focused for a specific reason rather than just having a general trawl of the internet. And I think it's really important as well to ensure that any managers who are involved in the recruitment process are trained on this and understand, and that you have policies around what checks are appropriate. I want as well to talk about GDPR. Obviously, under the GDPR, when you're collecting any information about candidates during a recruitment process, you need to comply with basic principles in relation to data protection, which means that you should have a lawful basis for processing any candidate data, such as the legitimate interests of the business. Your searches should be proportionate, which we've already touched upon. So stick to what's necessary and relevant. And also, you should be transparent about what you are doing. If you're relying on legitimate interests, your business's legitimate interests in screening candidates, it really involves a balancing exercise, weighing up the individual's expectations of privacy and their interests in that privacy, and your interests in vetting your candidates. And clearly, the more intrusive your screening, the harder that's going to be to justify and less likely to be viewed as legitimate. Key obligation that I mentioned before is in relation to transparency. It's really important when you're recruiting that you provide candidates with a privacy notice. So that is a document spelling out certain prescribed information about how you are going to be processing any candidate data. And that privacy notice that you issue to candidates should be reaching candidates as early as possible in the recruitment process, So you might include a link to it in your job advertisements, have it linked on your website, or even emailed out to candidates, or a combination of all of those things, so that individuals as early as possible are getting information about how you're using their data. The information that needs to go into privacy notices could in itself be a webinar. We can help, and we advise clients on the content of their privacy notices for both candidates and employees. So you can get in touch with us if you need support on that. But I've also included some basic guidance from a link on the slide to the Information Commissioner's website and their basic information about making privacy notices. So hopefully you'll find that useful. Moving to my next slide, I now wanted to talk about right to work checks. And by this, we mean the checks that you need to conduct on staff in relation to ensuring that they have the right to live and work in the UK. Starting point on this topic is that it's unlawful to employ people if you know or have reasonable cause to believe that they don't have the right to live and work in the UK, or that they're working in breach of their conditions of stay. And employers who breach these obligations face pretty extensive criminal and civil penalties, with a risk of imprisonment and potentially unlimited fines. So it's really, really important that anyone involved in recruitment is aware of these right to work checks and that you're staying on the right side of these rules. Employers do have a statutory excuse that protects you from civil liability if you conduct appropriate checks, and that you keep good records to be able to show and evidence that you've conducted the correct checks. And the key thing is that it's really important that your checks are conducted before employment commences. If you do it in the first week that somebody joins you, it's too late. You need to conduct checks before employment commences. So this is an important part of your recruitment processes. And for many people, it will just be a one-time check before people start. But if when you check their stay in the UK is only temporary, you may need to conduct ongoing checks throughout the life of the employment relationship too. So what checks are needed? Well, firstly, it's obtain an original version of one or more acceptable documents, often passport, but in certain circumstances, other documents too. To check the validity of that document, that involves meeting face-to-face with the individual and checking their document. And finally, making a clear copy and retaining that copy and recording the date of your check and the date of any necessary follow-up checks. The detail of each of those steps, that three-step process, is included in pretty good, really helpful government guidance, Home Office guidance, and I put a link to that there on the slide. And the Home Office, and that includes a link to all of the information, the documents that are suitable to be checked. So yeah, it includes the list of acceptable documents. There's also a link there to a really helpful checklist, the second link there. The Home Office recommends that you use this, and that's really good. It's got tick boxes so that as you're going through the process, you can tick off what steps you've done, and that's useful to use and to keep on file as well so that you can evidence your checks. Now, obviously, there is a problem with all of this at the moment, because meeting face-to-face with employees to do anything is pretty tricky at the moment. So I just wanted to mention that for the time being, during the pandemic, the Home Office did amend its checking procedures. So at the moment, checks are still necessary, but the process has been modified in recognition of the fact that it's hard to meet face-to-face with people. Effectively, at the moment, you need to get people to email you a scanned copy of your documentation. You then arrange a video call to check that documentation. It's good practice to screenshot that call if you can, so that you can show and evidence that it took place. And then you mark the document as checked, using the wording adjusted check due to COVID-19 undertaken on a particular date. The really important thing to know in all of this is that when the temporary, at some point, the Home Office is going to say, okay, back to normal. And when that happens, you're going to have 8 weeks in which to go back and conduct full retrospective checks on all of the people that you've just done modified checks for. So you are going to need to have good records of who you've done these temporary checks for, and make sure that somebody is tasked with going back and filling in the gaps and making sure that the full retrospective checks are undertaken. I've included a link here to some information about this temporary situation And that's all I wanted to say about that. So I'm going to hand back to Paula now, who is going to tackle our next topic.
Yeah,
which is all about taking offers of employment. Sorry, there you go, Paula, to you.
Awful photo. Yeah, just in the last couple of minutes, one thing we wanted to warn you about is it's very, very easy to make an offer of employment. So a warning that we do give is make sure that the managers who are interviewing don't get overly carried away and offer jobs without making some sort of protection for the business. Generally, we advise if you're offering employment that you make it conditional, and you make it conditional upon satisfactory references. We also say ideally in any offer and contract following it that you put in that contract that the whole agreement is incorporated in that documentation, just in case promises were made in the interview that may not quite be understood similarly between the parties. So it's always best to get those terms down in writing, make sure the eventual contract has a whole agreement clause so that you can clarify what the offer exactly is and what the individual is accepting. So references, what's a satisfactory reference when it's at home? The good news is that as long as you're not being deliberately discriminatory, satisfactory references pretty much is in the view of the employer. So you'd probably, if you'd offered a job to somebody, got a reference you didn't like, you would probably contact that individual. In fact, we'd advise you contact the individual and ask them to explain to you what had happened. But if a person looking at your decision would look at it and say, well, if I received that reference, I'm sure I would have withdrawn the offer as well, you're not going to be in any major difficulty. Criminal records and financial checks, you sometimes see these being carried out. Criminal records, you do need to be careful. And generally speaking, it's only specific roles that you can ask for any detailed criminal records in relation to. What we call the exceptional occupations, you can get a criminal record check. You could ask people to volunteer information, but who's to say that they're going to tell you the truth in that situation? So probably best just to take those sorts of checks on people where you can justify it for the role. References to people, former employers have to give references. Generally, no legal requirement. There are certain sectors, such as the banking sector, where it is a legal requirement, but other employers may choose not to. They do need to be careful, though, if that person that they are refusing to give the reference in relation to has brought a discrimination claim, because guess what? We're back at a new type of discrimination, and that is victimization. So if somebody had brought a claim but then is refused a reference because of bringing that claim, that would be victimization. And our last little reminder to you, the regulations changed in April of this year in relation to providing Section 1 terms and conditions, the basic terms and conditions for employees and workers. And as of April, you do need to give basic information on the job to new starters, and it's a day one right now to get those basic terms. It's not going to be your full written contract of employment, but if you are confused about that and want further details, ACAS have guidance on it, or we of course are more than happy to answer questions on that as well. Right, and I think I've slightly overrun, Nicola. But that is me finished.